Good evening, ladies and gentlemen. A very warm welcome to this Current Legal Problems lecture. My name is Mark D'Souza. I'm one of the editors of the Current Legal Problems lecture series and journal. My role this evening is largely ceremonial. I am just here to introduce our chair for tonight's lecture. The lecture, of course, is by Professor Melissa Lane on ancient Greek law as a lens on legal theory of promulgation and purpose. But our chair for tonight is the Right Honourable Lady Rose of Colmworth, DBE, who is Justice of the Supreme Court of the United Kingdom. She was called to the bar at Gray's Inn in 1984 and en route to becoming a Justice of the UK Supreme Court in April 2021. She has been legal chairman of the Competition Appeal Tribunal, a High Court judge, and a judge of the Court of Appeal. It's indeed a great honour to have you here moderating this event, including the Q&A session that will follow the lecture. For people in the audience, the format for today's event is that Professor Lane will speak for approximately 40 minutes, followed by about 10 to 15 minutes of Q&A, which we realize is very short, and therefore we invite and strongly urge you to join us for a drinks reception immediately after the lecture, just outside, where you might be able to catch Professor Lane and bend her ear about any burning issues that you weren't able to address during the Q&A session. So the only other thing I will do now is mention to you that we are not expecting any fire alarms. So if we have one, it's the real thing. Please take it seriously. And I will now ask our chair, Lady Rose, to introduce our speaker for the evening.
Thank you very much, Mark. Well, it's a real pleasure and a delight to introduce Professor Lane to deliver her lecture, which I think is an important contribution to this year's Current Legal Problems lecture series for 2025. Professor Lane received an MPhil and PhD in philosophy from the University of Cambridge, where she then taught for 15 years before moving to Princeton in 2009. She is the class of 1943 Professor of Politics at Princeton University, and she's also associated faculty there in classics and philosophy. But luckily for us, she's currently on sabbatical. She spent the autumn of 2024 in Oxford as the Isaiah Berlin Visiting Professor in the History of Ideas, and she's now in London as, amongst other things, Honorary Visiting Professor in the Department of Philosophy here at UCL. She has held a number of prestigious fellowships over the years, and she's been a visiting professor in the US on both the West and the East coasts, in Europe and in the Southern Hemisphere. And I hope that that shows not only what a world-renowned scholar Professor Lane is, but also what a sociable bunch fellows in classical philosophy are, zipping around the world, visiting each other all across the globe. She's also much published. Her most recent monograph, entitled Of Rule and Office, Plato's Ideas of the Political, was published in 2023 by Princeton University Press and was awarded the 2024 Book Prize of the Journal of History of Philosophy. Professor Lane has the distinction of being the only person ever to have delivered both the Carlisle Lectures in Oxford, which she did in 2018, and the Isaiah Berlin Lectures, also in Oxford. And she's also well known for her work in bringing classics and philosophical ideas to a lay audience, since she is one of Melvin's go-to guests in the BBC radio programme In Our Time, most recently discussing Hayek's Road to Serfdom. The title of her lecture this evening is An Ancient Greek Law as a Lens on Legal Theory of Promulgation and Purpose. Most law students and legal practitioners like me will have some familiarity with Roman law, and quotes from Justinian do sometimes crop up in our judgments in the Supreme Court, but I think you're going to refer to the fact that ancient Greek law is rather less familiar, so I'd be very interested to learn about it. Please join me in welcoming Professor Melissa Lane as I invite her to give her lecture.
Thank you so much, Lady Rose, for that extraordinarily kind and thoughtful introduction, and to Professor D'Souza, to Christina Giannacopoulo, and everyone involved in organizing tonight's lecture. So indeed, when one considers the overwhelming presence of Roman law in modern jurisprudence, it is striking that ancient Greek laws are unfamiliar to most legal scholars. Yet at the heart of Justinian's Institutes is a passage that puts Greek laws at the root of the Roman civil law. And this distinction, which it draws, will be central to my lecture tonight. So this is a rather formidable slide, but let me walk you through it. So it begins, our law is partly written, partly unwritten, as among the Greeks. And I'll come back to the inset bit, but to go on, this division of the civil law into two kinds appears to have originated in Athens and Sparta. And here's the crucial distinction that will structure the lecture. It was usual in Sparta to commit to memory what was observed as law, while the Athenians observed only what they had made permanent in written statutes. And so you can see that the contrast is between written statutes, more familiar to us, and committing to memory. And that's a gloss on the inset bit of the quotation, which refers to ancient customs which come to constitute unwritten laws. So according to the institutes here, both written laws and unwritten customary practices are tools for what I call the promulgation of laws. And I mean by that, how laws are made public such that they can be known by those who are subject to them. Now, this passage of the institutes does not mention lawgivers, but Greek and Roman authors alike had long attributed these differences between Athens and Sparta, so the Athenian reliance on written laws, the Spartan reliance on unwritten customs, they had attributed those to their different lawgivers. And so you see on the one hand, Lycurgus of Sparta, who may have been a real figure, may have been a mythical figure, we don't know for certain. Probably, if he did live, lived between about the 9th and 7th centuries. He's the famous Spartan lawgiver. And I'm going to also focus on Solon of Athens, who's the second of two great lawgivers in Athens. He was active around 600 BCE. He followed in the wake of Draco, whose laws lasted only in the area of homicide, and that gives us the vocabulary of draconian punishment that we still use today. But these two figures, Lycurgus and Solon, are the two lawgivers whom Aristotle would name as craftsmen of constitutions. So Aristotle draws a distinction between those who were craftsmen of constitutions, which include Solon and Lycurgus, and those who were only craftsmen of laws. And so in the Greek and Roman minds, Solon and Lycurgus are the lawgivers who are responsible for the major outlines of the constitutions of Sparta and Athens, of Athens and Sparta, and for their distinctive means of promulgation, for writing on the one hand and unwritten customs on the other. So let me make two brief notes of context, and they're both encoded on this slide. So first, I've used the word constitution, and you may be wondering, in what sense did the ancient Greeks have constitutions? Well, they did not have exactly the same understanding of the distinction between constitutional laws and ordinary laws that we do today. But they did have constitutions. So I use that word, as many scholars do, to translate the Greek politeia in the singular. And they understood constitutions to comprise political offices and institutions together with fundamental laws. So Solon and Lycurgus were distinctive as craftsmen of constitutions because they reshaped the political institutions as well as the fundamental laws, habits, and customs of their communities. And the second point of context that I want to make here is that both of these august lawgivers acted within already existing legal systems. So one might have imagined that when we speak of these Greek lawgivers standing at the origin and foundation of Greek law, that you might imagine, well, that means they originated Greek law. There was no Greek law before these figures. But in fact, that's not the case. Laws didn't have to be made by lawgivers. They could be made by councils or assemblies in varying ways that developed over time. But what the great lawgivers did was to engage in extraordinary occasional acts of refounding laws and constitutions. And I'm going to argue characteristically doing that at moments of political strain or crisis. So I'm going to emphasize this language of reconciling political communities, and we'll see that that's the explicit language that ancient Greek authors used to describe Solon, and I extend it also to apply to Lycurgus. So my focus for tonight's lecture then is to explore these two linked themes: the role of the lawgiver in promulgating Greek laws, and I'll argue that their promulgation was linked to this purpose of reconciling their communities, but also the contrasting means that we saw in Justinian's institutes that they used to do so. So Lycurgus dictating orally his laws, Solon writing his laws, and we'll explore that in more detail. Now, writing was a relatively new technology for the Greeks, and even relatively new, therefore, for the Romans. Alphabetic writing was imported into Greece from Phoenicia only in the 8th century BCE, and this is an example of one of the earliest surviving bits of inscribed writing from the mid-8th century, and the oldest surviving inscribed Greek law is from about 100 years later, from the mid-7th century. So what's interesting about that is that we can think of that as a new technology to the Greeks. So just as we have new technologies in which we're using writing in new ways on the internet, writing itself, alphabetic writing, was a new technology, top of mind for them. And so their reflections on its advantages and disadvantages, its benefits and drawbacks, I think, are quite instructive as we think about the relationship between writing and law also today. So the lecture will have two further parts, followed by a brief conclusion. So part one, which will be the longer part, focuses on explaining the link between promulgation and purpose. And it will begin with the Hart-Fuller debate in legal theory, and then move on to discuss Solon in light of that debate, and to compare Solon in particular with Fuller. And then part two, which will be briefer, will explore further these contrasting tools of writing and memory as ways of promulgating laws and legal purposes. And I'll say more then about how the Athenians deployed law and how Lycurgus did not deploy written law, at least as tradition tells it. And I'll conclude with some very brief reflections on what we might draw from this interplay between legal history and legal theory today. So part one on promulgation and purpose. And let me begin by putting these questions within the framework of the philosophy of law, and in particular, the debate between Hart and Fuller, which of course will be familiar to many of you, but I will rehearse the crucial bits for my purposes. Now, you might think it's strange to start with the work of H.L.A. Hart, his great work on the concept of law, because it might seem that the ideas that I'm exploring in the Greeks are quite alien to Hart's approach in that work. So Hart there, of course, offers an evolutionary account of the emergence of legal systems. So it has little room for any special function of promulgation, or you might think special figure of a lawgiver. That doesn't seem something Hart needs. And of course, as a legal positivist, his account has little room for any kind of normative or moral purpose of law. So you might think, why start a lecture about Greek lawgivers with such an alien context? But in reviewing Hart's theory, I'm going to suggest that actually the function of what he called a rule of recognition, which is the key way in which he argues that a legal system could be identified and constituted, was in fact embodied by Solon and Lycurgus and other Greek lawgivers. So that's my punchline of the first part of the lecture, but I'll flesh it out in a few minutes. The idea is that these lawgivers served as embodied rules of recognition. And then I'm going to go on, though, to suggest that as embodied rules of recognition, they served a further purpose than what Hart would have countenanced, namely, broadly speaking, the kind of normative purpose that Hart's critic, Lon Fuller, held to be constitutive of good law. So to make that case, let me start with a little bit more on Hart and the absence of an interest in promulgation, in a way, in Hart. So Hart asserts that, well, yes, legal rules might start by being written down. He kind of takes an anthropological view here. But he asserts that writing down first-order legal rules is, as he says, not itself the crucial step in the emergence of a legal system. So that kind of written promulgation is not necessary, nor is it sufficient for a legal system. Instead, the crucial step is what Hart called a rule of recognition. So I'm going to use the terminology, which is not exactly his terminology, but I'm going to say this is a higher order rule that identifies which first order rules count as such. So in other words, a rule of recognition is a rule that identifies which laws count as the laws of a given society. Now, the rule of recognition, then, is no ordinary rule. It doesn't have to be written down. It doesn't have to be promulgated in a declarative statement. It's rather more like a practice of acknowledgement. So it's the acknowledgement, in Hart's words, of reference to the writing or inscription as authoritative. It's a kind of practice. And so Hart says that this kind of acknowledgement has to be incorporated into what he calls the legal point of view. Promulgation is not what's crucial. It's the practice, the internal point of view, which says that these are our laws. So how does this account fit with Greek lawgivers? And in a moment, I'll also say more about how we can extend it to incorporate the perspective of Lon Fuller. So let me then explain this idea that we can see the Greek lawgivers as embodied rules of recognition. So when later generations of Greeks looked at their laws, what they did was to say, to identify them as the laws of Solon in Athens and the laws of Lycurgus in Sparta. In other words, recognition of these lawgivers was the form that the rule of recognition in each society came to take. So I like to say that this appeal to these historical singular lawgivers became a façon de parler for the later Greeks, which was also a façon de penser. It was the way they came to think about as well as to speak about the existence of their laws. So these lawgivers became focal points for identifying and recognizing the validity of the laws that they had made. Now, for Hart, the rule of recognition serves merely to pick out the existence of a legal system. So as you see here on the left pit of the slide, we can say in technical terms that Hart focused simply on the epistemic function of a rule of recognition. And all I mean by that is that it's a way of enabling people to know which laws count as their city's laws. So if an Athenian was saying which laws are our city's laws, the answer would be the laws of Solon. But I want to also suggest, and this is where I come to Fuller, that the Greeks also moved beyond that function of the lawgiver, because they also saw the lawgivers as serving what I call a justificatory function in relation to the laws. And this is because these great lawgivers were not viewed as having just arbitrarily selected any laws. Rather, they were ascribed special abilities for selecting laws wisely. And indeed, this is the grounds on which they were designated as lawgivers in the first place. And we'll see that in the case of Solon in more detail shortly. So we can call this a justificatory function because it also gives people a way of knowing not just which are our laws, but also that these laws are good laws. The role of the lawgiver underpins that claim. So we can illustrate this with the case of Solon, right? The figure of the lawgiver can be invoked to answer the question, which laws are the laws? Well, these laws are our laws because they are Solon's laws. But it can also be invoked to answer the question, why should we consider that these are good laws? Why should we continue to accept them and to acknowledge them as our city's laws over generations, indeed centuries, in the case of both of these figures? And the answer is, well, because they were Solon's laws, and Solon was a wise lawgiver. And so this combining of epistemic and justificatory functions, I think, is at work behind the scenes, and I think it helps to show how we can extend from Hart's perspective to that of Lon Fuller. And one of the things that's striking about Fuller's work, this was his great monograph, The Morality of War, which of course, The Morality of Law, which is of course in part a critique of Hart, explicitly so. One of the interesting things about this book is that Fuller himself invokes the figure of a lawgiver or legislator. Some of you may run over Fuller in your minds, and I'll try to remind you of how this is the case. It's quite striking. Hart does not mention lawgivers practically at all, but Fuller actually does. He adopts it as a standpoint within his own work. So, for example, in the crucial chapter on the morality that makes law possible, Fuller speaks of having adopted the viewpoint of a conscientious legislator. And I'm using these words synonymously, legislator and lawgiver. And elsewhere in the book, for example, he sums up the challenge of balancing the multiple desiderata of good law with the observation that this challenge is, and I quote, no less an undertaking than being a lawgiver. So it's quite striking. You might think as you read this work, who is he talking about? What lawgiver is he talking about? He doesn't identify this figure. It's a kind of, again, a façon de parler. And I think it is a façon de penser for him as well, because I think it's intrinsically linked to the idea of law having a fundamental normative purpose. So this goes back again to that idea of Aristotle's that the lawgivers are craftsmen. If we think about an object having a purpose, one natural way of thinking about it is, what was the purpose of the craftsman or woman, the craftsperson, who made that entity? That's a natural way of thinking. And to me, this is what actually explains Fuller's rather perplexing invocation of the standpoint of a lawgiver, is that indeed he is trying to articulate the perspective that law has this fundamental purpose. So for Fuller, this is the purpose of law. It is a very general purpose, the enterprise of subjecting human conduct to the governance of rules. And he emphasizes that this is an aspirational ideal. It can be achieved more or less well or fully. Now, broadly speaking, I'm going to argue this is the same purpose that Solon and Lycurgus were also pursuing. They were seeking to subject the conduct of the Athenians and Spartans to the governance of their newly reformed legal rules and institutions, to the reformed constitutions that they laid down. But as I now turn to consider the case of Solon in more detail, we'll see that it highlights, it identifies an underlying social tension that had to be confronted in achieving that purpose. Because if you want to subject human conduct to the governance of rules, you need to ensure that both sides, all sides in a given society, are willing to play by the same rules. And so this is the fundamental purpose of the lawgiver as reconciler. And I see Solon and Lycurgus as on a continuum, which embraces this common purpose. So the ancient Greek lawgivers were trying to reconcile all parties to play by the same rules. For Solon to do that with written laws, and of course, Lycurgus does it by seeking a more specific purpose of unifying customary practices. But I think they both fall under this common umbrella. So let me now try to make that case for Solon now as reconciler. And I focus on Solon here because we know more about him, and we know that he was a real historical person as opposed to Lycurgus. So a little background on Solon. He's a real historical person. He was a sage, one of the 7 sages of Greece, and many of the lists of the sages, as well as a poet, as well as a statesman and lawgiver. And he was born into an elite family, but with depleted wealth. And so he went into trade, which was rather unusual for someone of his high social standing. And this brought him into contact with people across this fundamental social and economic divide. So broadly speaking, we can talk about an 80-20 cleavage in the Greek societies of the time, including Athens. Perhaps 20% were the wealthy landed elite to which Solon's family originally belonged. And the other 80% would have ranged in wealth and independence, some of them small craftsmen or farmers, some landless laborers, many of whom were in danger of debt servitude or full-blown enslavement if they fell into economic misfortune. And while I'm not focusing on it in this lecture, some of Solon's most important acts were actually abolishing a certain kind of debt bondage and also the cancellation of existing debts. So I'll be happy to say a bit more about that in the discussion. So you can see here that Solon's reputation for wisdom then rested on his engagement in travel, his getting to know people from many different social backgrounds, both at home and abroad, and his study of and skill in the public performance of poetry, which some have compared to being the television of Greek times. It's the kind of mastery of social media. Solon was a master of the public performance of poetry. So this is crucial then to the basis on which he was chosen to act as a lawgiver. And so we can see then why and how he was chosen. This is in the account of Plutarch, which is a much later account, but one of the 2 major narrative sources that we have. And Plutarch says this was a time of social tension between the rich and the poor in Athens. And there was a kind of movement of the poor to change the constitution in their own favor. And in response to that, a group of the wisest of the Athenians saw Solon as someone who was associated with neither side. He was neither associated with the rich nor with the poor. And so he was the person who could uniquely act as reconciler. And so we have in our 2 sources, so Plutarch is much later, writing in the 1st to 2nd century CE. We also have a 4th century narrative that's from Aristotle's school. That's the second one, the Paul. And so they give us slightly different accounts, but I'm going to try to explain how they fit together. So if we look at the account from from Plutarch at the top, we see that he says that Solon was chosen for 3 roles. So he was chosen as archon. That's an elected, established annual office at the time. But what I want to emphasize about that role is that that's not a law-making role. The archons were more like executive office holders. So if he were only archon, he would not have been a lawgiver. So he becomes a lawgiver in virtue, in Plutarch's account, of these 2 additional roles. So he's also chosen as a reconciler, that's literally the word in Greek, dialaktes, and as a lawgiver, nomothetes, that's the Greek. And as I see this then, I think what we can say is that the reconciler role tells us the purpose for which he was acting, and then lawgiver is the way by which he achieved that purpose. And I think that makes sense of the other narrative where we see that he was chosen as reconciler and archon. There it doesn't specify lawgiver, but you can see that elsewhere in the same source it says he established a constitution and laid down laws. So he clearly acted as a lawgiver, but we can sort of subsume his role as a lawgiver under this umbrella of reconciler. And so Solon was a lawgiver who was harnessed to the purpose of social reconciliation, getting everyone to agree to play by the same set of reformed legal rules. And we can see that aspiration in his surviving poetry. These poems were written down probably a century or at least after Solon lived, so they're not necessarily all exactly his words, but scholars nevertheless believe that they are good pointers to the sort of thing that he may have written. His poems would have been initially passed down orally before they were written down. And what we see here in two of his poems is that he says, I wrote laws equally for poor and rich. I made justice that is fit and straight for all. And he acts between the two parties in this cleavage. He took his stand like a boundary stone between the rich and the poor. And how did he do that? Well, he reformed the Constitution and made new laws. And in this quotation from Plutarch, you see the emphasis on the Constitution involving the institutions of government. So he reforms the magistracies, those are the offices, the assemblies, the courts, the councils. He changes the qualifications to serve on those, their times of meeting, right? He abrogating and maintaining existing institutions at his pleasure. So he is a constitutional reformer and a lawgiver seeking the purpose of social reconciliation and doing so fundamentally by means of writing. So you may have noticed in one of the poems that he says, I wrote laws, and we'll see in more detail how his laws came to be transmitted through writing. So that brings me to the final section of part one, and then part two will be much briefer. And here I want to compare Solon and Fuller on the structure and nature of law. So what I've tried to argue is that in a way, Solon is pursuing Fuller's purpose, subjecting human conduct to the governance of rules, but he has to get everybody to agree to do that. So there's a kind of social challenge at work if we're going to meet that goal of the philosophy of law. But what's striking is that in doing that, Solon uses laws in a way that I think is very similar to Fuller's ideal of what he called the inner morality of law. So Solon has an ideal that he calls eunomia, lawfulness, or some scholars translate it law and order, good order. And I want to very quickly run through the parallels to Fuller's morality, inner morality of law. And the point here is that if you want to pursue this purpose, you have to pursue it with laws of a certain kind. And it's striking that indeed Solon did that. So here's a summary, and I'm going to run through it very, very quickly. So on the left, you see the 8 desiderata of the inner morality of law as Fuller lays them out. And on the right are the bits of evidence that Solon actually meets these desiderata. And I'm going to just very quickly run through this for you. As you can see, for 6 of them, I think it's an absolute tick. For 3 and 4, I've put a tick and an X, and I'll explain that he sort of meets those desiderata. But the other 6, I think he meets very fully. So just very quickly, right, first of all, these have to be rules rather than ad hoc judgments. This is a different translation of that same line of poetry. Right, yeah, I wrote laws, so we're making rules. It has to be publicly promulgated. And again, notice this is a desideratum for Fuller, whereas it was something that Hart didn't actually emphasize very much. And here we see that it was done with Solon's laws through writing. So all of his laws were inscribed on axonas. These were wooden notice boards on which the laws were written up all over Athens. They should be prospective rather than retrospective. This is a little bit of a fudge, but I think it does touch on the issue of prospective versus retrospective. Okay, this one is a little bit of a question because Fuller says laws should be understandable. And Plutarch says, well, actually, Solon made some of his laws obscurely and ambiguously worded. So you might think he fails on that criterion. However, Plutarch goes on to explain why did he do that? To enhance the power of the popular courts. In other words, this was part of his effort to rebalance the power of the rich and the poor. So he's using a different means to achieve the goal, the purpose overall of his reconciliatory laws. Okay, non-contradictory, he doesn't quite do so well on that one, at least according to Plutarch on his laws on women. Possible to follow, however, this is quite an interesting one. So Solon was later asked, had he provided the best laws for the Athenians? And he answered, the best that they would accept, right? So the best laws that it was possible for them to follow. They were sufficiently stable. They were fixed to stay unaltered for 100 years. And they were congruent with their actual administration. And one of Solon's innovations was to empower every citizen to act as a kind of public prosecutor. Any citizen could bring a suit if they believed that the laws were violated, and that enables the laws to be sufficiently administered. Okay, so what we can see then is that overall, Solon's work as a lawgiver exemplifies all or most of the features of good law that Fuller would highlight and require. And I think this is interesting because it suggests that by studying the history of Greek law, we can actually support the thought that there are inner normative constraints on the nature of law that in fact are necessary or at least facilitative of the achievement of the social purpose of law. So promulgating law in this way, and in particular through writing, was one way of achieving that purpose. So let me now turn very briefly to part 2, where I want to return to the question of the two contrasting ways in which Athenian and Spartan laws were promulgated. And just to remind you again, here we're going back to that original quotation by Justinian. I'm going to say a bit more about the Athenians and written law, and then a little bit about the Spartans and oral practices and unwritten customs. So we've already seen that Solon's laws were written, and that was an important feature of them. And we see that also in this quotation by a later author that describes the way that Solon's laws, again, were written up all over the city. But there's also a later moment in which the Athenians doubled down on the writtenness of their laws. And I think this is actually probably the moment that the compilers of the institutes had in mind. And this is just after Athens has lost the Peloponnesian War to Sparta. There's been a brief oligarchical junta, which is overthrown. Democracy is restored. And the restored democracy doubles down on the writing of their laws. So they now compile a written code that's written all in one place. So rather than all the laws being posted up all over the place, they now have a kind of body of laws, as we would think of it, kind of written down, including laws that had been made since Solon's time, but which they still thought of them as the laws of Solon. They kind of brought all these new laws under that umbrella. And so they now approach much more what we would think of as legal consistency and the consistency of written laws. So no law should be enforced which has not been issued. No decree shall override a law, right? This is kind of familiar to our idea of the rule of law. And part of this was also a new system for changing the laws. So now that the laws had all been written down, laws could no longer be made by the assembly. Instead, individuals could propose changes, and then there was a kind of jury that could definitively vote a change up or down. Now, what I want to emphasize here is the importance of consistency. What the proposers and the, as it were, jurors were charged with doing was maintaining the overall consistency, not just of the body of laws, but with the original intention of the lawgiver. So, for example, as the orator Demosthenes puts it, it's crucial that any proposer of changes to the law maintain an intent which is consistent with the original intention of the lawgiver, and they most often meant Solon in that way. So what's interesting about this is if we compare this, for example, to Dicey and the British Parliament, which can make or unmake any law, so could the Athenian, these bodies of jurors, as it were, but they were normatively constrained. They had to maintain consistency with the purpose of the original lawgiver. And so the written laws still had to be animated by the spirit of the lawgiver. That was the way that written laws could function. Okay, so very briefly then, let me transition from Athens to Sparta. So here we have the proposers of the written laws, the changes to the laws there in Athens. Okay, so let me now transition from Athens to Sparta. And what I want to do by doing this is to say, well, in 403, the Athenians thought there were all these great advantages to written laws, the kinds of advantages that we easily recognize. They make laws general, they make laws fixed. Those seem to be very good things, right? Generality and fixity, and ensure fairness, equity, consistency, planning, all those things that we know about the rule of law. But on the other hand, generality and fixity, especially through writing, can also have disadvantages. It can lead, generality means laws aren't always precise or specific, and excessive fixity can make laws inflexible, right? And so written laws can become inflexible, and that's why the Spartans instead appealed to memory and practice. And so my last main section before a brief conclusion is to briefly introduce you in more detail to Spartan oral custom. So there's no epigraphic evidence of inscribed Spartan laws. And that has supported a tradition which formed, which claims that Lycurgus had prohibited the writing down of his laws. Now, I myself am a little bit skeptical about whether that's actually true, but it's a very influential tradition about Sparta. And it goes with a different vocabulary for law. So the Athenians and many other Greeks referred to the laws often as the writings, but Lycurgus refers to his law as heretra, the spoken thing. So you see, even in the vocabulary, that there's a distinction. And so it's again Plutarch in his account of Lycurgus who most famously gives us this story that Lycurgus prohibited the writing down of his laws. And so here we see why he did that. He thought that if the most important and binding principles were implanted in the habits and training of its citizens, not in writing, they would remain unchanged and secure. So notice that this is a different claim about how to make law fixed and ingrained, not writing, but habits, training, memory, practice, observation is the alternative and purportedly better route. And Plutarch goes on, it's better not to hamper people with written constraints and fixed usages, even for business contracts, I know an area of special expertise of our distinguished chair. Instead, it's better for people to be able to flexibly alter their views. And Plutarch goes on in another work to offer other views about why this is superior. So he says, when Lycurgus was asked why he had not made use of written laws, he said, those who are trained and disciplined can determine what is best for a given occasion. And it's better to accustom the young, this is a Spartan king, to deeds of valor than to have them study writings. So what this is suggesting is that if we may have the very same aims of, in some sense, fixity and appropriate laws, but perhaps writing has Achilles' heels that make it not always the best or only way to achieve that. And if the purpose of law is civic reconciliation and unity, the tradition associated with Sparta, here is the training ground of ancient Sparta for training the youth in those deeds of valor, may be better inculcated by memory and practice, by unwritten customs, rather than by written laws. So to conclude, let me offer you a crib sheet to take away. This is a statement by an historian of ancient Greek law that I think captures well the argument that I've tried to elaborate. And this is the idea that the Athenians saw Draco and Solon as the authors of their laws. And so they saw the laws as, in a sense, above ordinary politics. And the job of everyday democratic citizens was to maintain fidelity and consistency with the original intention of the lawgiver who had promulgated laws in order to achieve this reconciliatory purpose, and so maintain them as consistent and coherent. And one of my students helped me make this slide to illustrate that point. If you ask the Athenians, even the democratic Athenians, who authored your laws, they would have said not we authored them, but Solon authored them. And so we can close with a comparison to the common law. This is a reflection of J.R. Seeley, one of the great students of the history of English law, writing in the early 20th century. And he says, in the past, law was a sacred custom. Legislation was conceived as a very high power. This is unlike the modern state of the early 20th century, which makes and unmakes laws and thinks of it as just the opinion of the majority. So again, I've tried to suggest that perhaps surprisingly, the common law tradition has more in common with the ancient Greeks' veneration of their lawgivers than we might have expected. And in particular, they share the idea that the purpose of law and constitution must include getting opposed political factions to agree to follow a certain set of constitutional rules. And that's, of course, a project that remains arduous in far too many places around the world today. So to leave you with this final question, the challenge of promulgating laws for the purpose of social reconciliation, how do we get all sides to agree to play by the same rules? And what is the place of writing written law, written constitutions in doing so? Many thanks for your attention.